Race and the death penalty. Supreme Court to hear case of Curtis Flowers, tried 6 times for quadruple. Winona, miss yearly. One hot July morning in 1996, 4 people were executed in Tardy Furniture Store, a mainstay of this town's compact business district. Months later, Flowers was tried in 1997 and 1996 times. District Attorney Doug Evans, who is white, has attempted to convict Flowers, who is black, in a prosecutorial pursuit that may be without parallel. 2 trials. As it happens, the only ones with more than one African American juror have resulted in hung juries. 3 convictions were overturned by the Mississippi Supreme Court for prosecutorial misconduct and improper maneuvering by Evans to keep blacks off the jury. But the 2010 conviction was allowed to stand and Flowers was sentenced to death. Next week, the case has attracted national attention. Nobody gets tried 6 times but Curtis Flowers, said Robert Dunham, executive director of the Death Penalty Information Center. A bipartisan, when there is reason to believe that a prosecutor is exploiting racial bias and division in an attempt to obtain a conviction, the courts must take strong action, former Obama administration Solicitor General Donald B. Verrilli, Jr. The justices on Wednesday will examine the jury aspect of Flowers' conviction. But a separate team. Curtis Flowers is innocent of the Tardy Furniture Store murders, the lawyers write in a 321-page petition for post-conviction relief filed in the Mississippi courts. The dead were Bertha. Flowers' lawyers say newly discovered evidence shows previous convictions were obtained through false testimony by key law enforcement witnesses and a jailhouse snitch, suppression of material evidence, egregious racial discrimination in jury selection, and reliance on false and discredited forensic evidence. The series of reports by the podcast people, as some refer to the reporters from American public media, have been unwelcome for some here. And so have the leaked. Mississippi voting rights advocate Fannie Lou Hamer described the beating she received from Winona police in her famous speech to the Democratic National Convention in 1964, according to the brief filed by the NAACP Legal Defense and Educational Fund. The train station across the street from Tardy Furniture is where Emmett Till ended his ill-fated trip from Chicago in 1955. The 14-year-old, the Ku Klux Klan has marched in Winona, and the revelation. Martin Luther King, but the town's current leaders resist suggestions of a modern-day racial divide. There's never been an issue except to get to the truth, said Mayor Jerry Flowers, who is white and is not related to Curtis Flowers, he said, as far as we know. He jokingly called Winona Police Chief Tommy Bibbs, who is black, takes a similar view. That was then and that statue ain't done nothing to me, Bibbs said. Bibbs, who was not involved in Flowers' arrest in 1996, said many of those who proclaimed his innocence have not been to the trials or read the transcripts. The one in 2010 lasted 8 days, and the jury convicted in 30 minutes. As far as him being the culprit, no, I have no questions about that, said Frank Ballard, the son-in-law of Bertha Tardy. I do not believe Evans, the district attorney, did not return requests for interviews. When this reporter, a questionable conviction. Bertha Tardy was more than a furniture saleswoman. She had been to local businesses and banks would come in and say, we're putting a new lobby in, or we're changing the boardroom, Ballard said. She was the go-to. Rigby was quiet, and could usually be found at the counter, in the center of the store. Golden, Stewart was a popular high school athlete, and at a game the night before, Alderman David Ware's son caught and Stewart pitched. He was a helluva pitcher, there's no telling what he could have done, Ware said. Each of the victims was shot in the head. Stewart was the only. Tim Beeland, who at the time was editor and publisher of the Winona Times, said the shocking news was difficult for the town to process. It was just like small town anywhere. I'd park my car behind the newspaper office and never even take the keys out of it for the rest of the day, Beeland said. It's like all of that. Rumors were rampant, and Beeland had left to run another newspaper, the Scott County Times, before prosecutors turned to Flowers, then 27, who was indicted in March 1997. Flowers had briefly worked at the store that past July. But he had improper. Flowers maintained his innocence, and Evans had to build a case against him bit by bit. There was no physical. The testimony against him came from a string of witnesses who say they saw him at various points along a long walk across town before and after the shootings. There was a particle of 3 jailhouse informants over the years, said Flowers confessed to them. All 3 later the most dramatic came from Odell Hallman, now serving a life term for murder, who during the 2010 trial testified against Flowers. But speaking to a group called Friends of Justice highlighted Flowers' case. The Stars Network's Nelson Forrest, a Methodist minister who is related to Curtis Flowers, says the podcast especially has made a difference in how people in Winona view the case. It shocked a lot of black folk, Forrest said. People used to trust a question of discrimination. When the U.S. Supreme Court takes up Flowers v. Mississippi on when picking a jury, some are eliminated by the judge and lawyers for cause that they are likely to be biased, for instance, or because they say in a capital case that they could not impose the death penalty. Prosecutors and defense attorneys also receive what are known as peremptory challenges. They can strike but in a 1986 case, Batson v. Kentucky, in a more recent decision, the court said judges should consider the totality of the circumstances when deciding whether a prosecutor was using the challenges as a pretext for barring jurors because of their race. Flowers' lawyers said that means looking at Evans' work in previous trials, not just the most recent one. The first 4 times Evans prosecuted Flowers, he struck every black panelist that he could, 36 in all, Generally, lawyers can come up with a race-neutral reason for striking a juror. But deciding whether a potential juror was struck is a fact-specific inquiry. And the Mississippi Evans' past behavior is not relevant, Mississippi Attorney General Jim Hood told the Supreme Court in defending the conviction. Flowers' request that the justices automatically assume the district attorney violated Batson based upon his previous violation of Batson in Flowers' third trial is without precedential support and is thus devoid of legal merit. Flowers' lawyers and supporters say that argument overlooks the larger point. There have been 70 reporters for the In the Dark podcast assembled a database of trials conducted by Evans' office. They found that Evans was more than 4 times more likely to strike a black potential juror as a white one. And Flowers' attorney. In the 2010 trial, Evans asked 145 questions of the black potential jurors he rejected. He made a total of. Evans has dismissed the reporter's study of his jury patterns. I don't know where that figure comes from, Evans told the Greenwood Commonwealth. I haven't listened to. The focus on race has been painful for some. There are racial problems everywhere, and anytime anyone in Mississippi tells there's not some type of racial problems, it's just a lie, said Beeland, the newspaper editor, who is white. Winona is but he notes, we also have African American elected officials, on the city and county level, we work together on schools. I think there were good Drop top, smoking, no cooking the hot bar. Fucking on your bitch, yeah, that. Looking up